And welcome back to Daily Justice. Our topic today is, can your ex move away or move out of state with your child? My guest today is Mark Hodgson, family law attorney here in Spokane, Washington. Mark, are there legal steps that parents must take before moving away with their child under a custody order in Washington?
Well, absolutely. And if anybody has like a parenting plan, the best part is the relocation statute is contained in every parenting plan. So what you need to do before moving is actually in every single parenting plan that is drafted by this office and every other office I know. So yes, the steps you have to take, we can go through them a little bit, but like one of the best things is, what is a relocation? Like we call it relocating a child. It's moving outside of the child's school district. Like whether they go to private school or not, like that's something to consider. Is like if you're in the Meade School District or District 81 in Spokane, those are two Spokane school districts. If you move from Meade to District 81, you need to give what's called notice of intent to relocate. That's a form. Okay, so giving notice is not enough to go, hey, Dave, I'm moving, 5 blocks down outside of the Meade School District. Not enough. You need to file the correct form. You need to serve the correct form properly through the mail and everything. It'll show how to do it. And you need to do that. If you don't do that, then you can run into all sorts of problems.
How does Washington define a relocation versus maybe a temporary move?
Temporary move, I don't know. I mean, a temporary move in my mind, off the top of my head, would be like your house gets flooded. So like you've got to move out of or your house burns down would probably be a better example of like, you're going to go move into, the suites that are on the South Hill or whatever for 6 months while your house is being rebuilt. That's clearly a temporary move. There's not an intent to permanently relocate. Whereas like if you're going to move to Seattle to take a job, that would be a permanent relocation.
So this is about the ex moving away with the child. If you object to the move, what legal options do you have and how fast do you need to act?
It's a little tough because Washington State gives, so if you have the child really the majority of the time and it goes past a certain percentage, then you get what's called a presumption that the move is in the best interest of the child. So if you're served with a notice of intent to relocate, you have 30 days to respond, or object really. You have 30 days to object, which is you have to file a legal action. It's a bit confusing if you're not a lawyer, and you have to file legal action to formally object to the relocation. And so the clock's ticking. If you do not respond within 30 days, granted, your parenting plan will still open up. However, they can move and you can't object. So the majority parent can move away and you can object to the relocation. However, if let's say you have 4 out of 14 days, then they're definitely going to get the presumption it's in the child's best interest. So you need to overcome a legal presumption that it's in the child's best interest. Can it be done? Yes. Is it tricky to do? Yes.
What factors does the court consider when deciding whether a parent can move away with that child?
The factors are great because they're actually listed in the statute. There's 11 factors in the statute. There's 10 for the final parenting plan. The 11th one in the temporary orders is whether or not it's likely to be granted. So it's the strength, nature, and character of the child. It can be 191 factors, which are known as like, sometimes drinking or, child abuse or something like that. If those come into play, it can be whether it's going to be harder on the child if you take the child away from the other parent than if, there's some difficult ones. Does the child have special needs? Does the child have any of these things that would make a move like just not good for the child? And so there's 10 very specific factors in the relocation statute that make it so that you can overcome the presumption, but it's tricky to do.
And then what happens if someone moves without giving proper notice?
It really depends. It should be that you have to come back, right? I mean, That's what you'd think. Sometimes they are made to come back, and that can be like if you were to just ignore this statute and you get a great job in Minneapolis, right? And you move and you take the kid with you, and the parent really hadn't seen the kid, more than maybe once, twice a month or something. The court could very well go, nope, come back. And it's very difficult for you to come back because you may have sold your house, you may have, gotten rid of your rental, you may have a new rental, there's all sorts of things that can happen. So if you don't follow this statute, they can't really force you to come back as an adult. You have the right to travel in this country so far, but you have the right to travel, but your kid, they can come back. They can make your kid come back, which means you could lose everything. So not following the statute, let's say the other person had the kid 4 out of 14 days. I always do 2 weeks because it's an even number. But so they have the kid 4 out of 14 days and you move and they bring the kid back and you're stuck in Minneapolis, you lose your kid. And you probably would have had the presumption to begin with. So it's very important to give the proper notice before you move. And you need to do it 60 days prior to the move.
Clearly, relocation can be complex, emotional, and time sensitive. If you're facing a custody move or need help protecting your rights as a parent, please visit HodsonLawOffices.com or call the number on your screen for your free consultation. There's also a direct link below this video.